Good morning, everyone. My name is Kate Stewart, and I'm the president of the League of Women Voters of Greater Tucson. Thank you so much for joining us today for this very important program on medical aid in dying. We are a nonpartisan organization encouraging informed and active participation in government. Our league in Tucson is celebrating its 80th anniversary this fall. Since it's a new season and we're doing our first program right now, we're going to start off this program with something new. We're going to do a land acknowledgement as part of our commitment to diversity, equity, and inclusion. We respectfully acknowledge that the League of Women Voters of Greater Tucson is on the land and territories of Indigenous peoples. Today, Arizona is home to 22 federally recognized tribes, with Tucson being home to the Tohono O'odham and Pascua Yaqui people. The League of Women Voters is committed to diversity, equity, and inclusion, and strives to build relationships with sovereign Native nations and Indigenous communities through educational programs, voter outreach, and advocacy. So without further ado, I want to turn it over to our moderator today is Mary Ganopol. She's one of our members who has done a fantastic job planning this program. So thank you so much, Mary.
Thank you, Kate, for that wonderful introduction. I love the land acknowledgement. I'm glad we're starting that now. My name is Mary Ganopol, and I'm pleased to be your moderator for today's program. I'm excited the topic, medical aid in dying, issues and perspectives, was chosen to kick off this new season of the voter education program. It's a topic often misunderstood by both voters and lawmakers alike. Since the bill has been proposed for nearly every year for 20 years by Arizona lawmakers, and rarely heard in committee, the League felt it was time to shed some light on this end-of-life option that is now available for millions of Americans, but not Arizona residents. We're so glad to have you join the conversation. We will hear from each panelist for approximately 12 minutes each, followed by Q&A for the last segment of the program. Our first panelist is 𝗩𝗹 𝗟tože. From 2013 through 2019, Val was the founder and executive director of It's My Death, which led a grassroots effort to pass a medical aid in dying law in the state of Maine. The law passed in 2019, and the organization is now serving the state under the name Maine Death with Dignity. Val joined Death with Dignity National Center in 2019 and is the nationwide campaign director. She engages with lawmakers and coalition organizations to promote and support the passage of active bills. She provides mentoring and training on how the law works, the eligibility requirements, and the safeguards. Val holds a Bachelor of Science degree in Industrial Technology from the University of Southern Maine and a master's in Human Relations from Tucson University in Bangor, Maine. She is an interfaith chaplain and currently studies with the Chaplaincy Institute of Maine. Val has 3 adult children and 2 grandsons who have stolen her heart. She is
Thank you very much. And thank you, Mary, for that introduction, and a big thanks to the League of Women Voters of Greater Tucson for sponsoring this panel discussion today. As Mary mentioned, I'm an employee of Death with Dignity National Center located in the place we now call Portland, Oregon. I am on the other side of the United States in the Northeast, a place known as Dawnland, and I live in the place we now call the state of Maine. It's an honor to be here today and to share with you regarding Death with Dignity or medical aid in dying. Today I'll talk a little bit about what Death with Dignity or medical aid in dying means in the context of United States legal and medical practice. We'll identify the legal and medical requirements for patient qualification in the United States, and these would be the general legal and medical requirements. Each state has some nuances, but these are the general requirements. And then we'll talk a little bit about some other terminology that's used in relation to the Death with Dignity laws and to the movement for aid in dying. In the United States, the legal prescribing of a single dose of medication that a patient will self-ingest without assistance, meaning they take it on their own, is what's known as assisted dying or death with dignity in the United States. The medication is in a lethal quantity. It's written by a consenting, attending healthcare provider, and these underlined sections in the slide indicate that the legislation itself would have a definition for what those terms mean. It's at the formal request of a qualified terminally ill patient, so this is a patient-directed decision at the end of life, and it follows a legally defined, safeguarded standard of care practice in that state. In order to qualify, these are the minimum requirements. A patient must be an adult and a resident of the state that has the law. They must be diagnosed with a terminal disease and have a 6-month or less prognosis, which is the same mile marker used for hospice. That has to be medically confirmed by 2 qualified healthcare providers. So a qualified healthcare provider would be something like a primary care physician, or perhaps an oncologist or something like that, someone who's medically qualified to make those confirmations. They must maintain capacity to make an informed decision. This is something that I know disappoints a lot of people, in that a patient who is working with their physician to make a request for aid in dying must have their own capacity and maintain that capacity throughout to the end of their life. So this would eliminate any diseases that would affect cognitive ability. They also have to have the ability to ingest the medication without any assistance. And if the patient, if either of the physicians question the patient's ability to make or capacity to make informed decisions, a referral to a qualified mental health professional for assessment is also required. So currently, aid in dying is available in 11 U.S. jurisdictions. First in Oregon in 1994. It was immediately held up by legal battle for 3 years, and actually was enacted finally in 1997 after it went to the voters for a second time on their ballot and passed by an even greater margin. That was followed by Washington. Montana does not have a statute. However, the practice is permitted in the state simply because there are no laws against it. Then the state of Vermont in 2013, and so forth, up through the most recent state, which is New Mexico, who passed their law this year. I'm using data from the Oregon annual report to just sort of illustrate a few demographics about who uses the law and under what conditions. Those who request medical aid in dying in the state of Oregon over the past 23 years are predominantly white, over 96%. I find that demographic really interesting because the makeup of the state of Oregon is actually only 74% white. So this tends to be something that appears to be a little more accessible to certain demographics than perhaps others, although there is no research to really define why it's predominantly white. Most of the individuals who request medical aid in dying have at most a doctorate, but at least have high school graduation or GED. Predominantly, if you look at those numbers, the majority of people have some college or above. And that really speaks to also a patient's desire to be fully informed about their health care and to be actively engaged in their health care. Most of the patients who qualify for the law and ultimately use it are also enrolled in and receiving hospice, about 90%, and 99% have some form of health insurance coverage, whether that's private, Medicare, Medicaid, or some other state insurance. The most common diseases are cancer by a vast majority. 74% of the users of the law have a terminal cancer. That's followed by approximately 11% individuals with neurological diseases. So diseases like ALS, some Parkinson's patients who are not cognitively affected, and so forth. And then there's a small number of other types of diseases that would bring a person into the realm of being terminal. National polling continues to show us that close to 3 out of 4 people, or 74%, support aid in dying for terminally ill people. And that is a majority approval across every demographic, whether it's age, gender, faith, or religious views, how often an individual attends church, political party affiliation, or political perspective in terms of conservatism or being much more moderate or even progressive. So that means that about 1 in 4 people, or 26%, oppose. I speak about opposition in terms of 2 kinds of opposition. One is individual opposition, in that a person would be morally or philosophically opposed to using the law for themselves. And then institutional organization is where some organizations engage in opposition to the laws passing to prevent anyone from having access. In terms of terminology, the terms that are appropriate to use in conversations around medical aid in dying are death with dignity, aid in dying or medical aid in dying, medical assistance in dying, and physician aid in dying, PAD. You'll see that term often used in professional journal articles and so forth. Inappropriate terms are suicide, assisted suicide, or physician-assisted suicide, euthanasia, or mercy killing. These terms are inappropriate because the laws themselves define the practice as not these things. And of course, suicide and assisted suicide also has the implication that an individual could go on physically living their life if they chose not to end it, and a terminally ill person doesn't have that option available. Every law enacted currently in the United States contains similar language that states that a physician is not authorized, nor is any other person, to end a patient's life by lethal injection, mercy killing, or active euthanasia. It also states that the actions taken in accordance with the law are not for any purpose to constitute suicide, assisted suicide, mercy killing, or homicide under the laws. And then there's usually some sort of language that would state that state reports can't refer to any act committed under the law as a suicide or an assisted suicide. There's also another caveat that's generally included that says under no circumstances is anything in the act to be interpreted as a physician or care provider's permission to lower a standard of care for their patients. And I wanted to be very brief today to give all speakers plenty of time, and so that we have a lot of time at the end for questions. So thank you very much again, Mary, and the League of Women Voters of the Greater Tucson area.
Thank you, Val. Following Val now will be Margot Champagne. Ms. Champagne is from Albany, New York, is a graduate of UC Hastings College of Law, and practiced law for 30 years in Washington, D.C. She served 12 years on the board of Compassionate Choices Arizona and was intermittently its president and vice president. She was a long-term member of the League of Women Voters. She now resides in Phoenix and continues to practice law, occasionally covering for other lawyers, and works as a substitute teacher in local high schools. Her hobbies include swimming, reading anything by Anthony Trollope, and listening to Mozart. She was the author of the League of Women Voters Arizona White Paper in 2013, which was entitled Considering End-of-Life Choices, the Oregon Model. Thank you, Margot.
My involvement in this issue began in 2002 when I was invited by a friend to go to a national convention on the subject in San Diego. What impressed me from the beginning was the variety of people attending the conference. There didn't seem to be any uniformity as to political party or religious background or occupation. The unifying impulse seemed to be having experienced a deeply traumatic death of someone they loved, involving an enormous amount of suffering that was perceived to be unnecessary. In listening to the speakers at that convention, it was like a light bulb went off in my head. I came back to Arizona and I joined the organization that had pretty much been around since around 1997 During this time, or shortly thereafter, there was a bill submitted in the Arizona legislature every year. And other than one time only, the chair of the committee assigned the bill always refused to hold hearings. And as we know, if there are no hearings, a bill dies in committee. So there was a lot of discussion about a ballot initiative and what was the chances of that. But the amount of money estimated to be needed for a ballot initiative was so enormous and so beyond our means that this was never tried. So during this time, these 12 years, we got out a newsletter, we had demonstrations, we lobbied, we did as much public education as we could. We called some of our demonstrations Million Geezer Marches. And we got a pretty good bit of publicity. So subsequently in 2011, I joined League, and when asked what issue I wanted to work on, I said this one, Death with Dignity. I was frankly discouraged. The League people explained to me reasonably that they had a shortage of resources and they needed to focus on their core mission, protecting and defending the democratic process. But I pointed out that League had already taken positions on other social issues. So when I was asked to be a delegate to a statewide conference in Tucson, I said, look, can't we at least do a study and take a position? And the process was explained to me, and it was very, very bureaucratic, very time consuming. It was estimated to take about 2 years. So I said, well, I want to get started. So it was agreed at that board meeting that I would submit a motion and it would fail, but I would learn the process. So I went to the conference, I submitted the motion, I was given 1 minute to defend it, and then the delegates voted, and lo and behold, it passed overwhelmingly. Everybody was surprised, not least of all me. So then I spent that summer, 2013, working on what League calls a white paper, which is intended to present the issue, both pro and con. I was very interested in focusing on the two entities that seemed to be the primary opposition, which was a subsection of the disability community, not dead yet, not the whole disability community. And secondly, not religious groups per se, but very conservative fundamentalist religious groups. But interestingly, at that time, a bill was submitted in the British Parliament, and the former Archbishop of Canterbury, Carey, came out in favor. This surprised everyone. He was asked in the British press, what gives? You've been opposed. You've always been opposed. And he said, quite frankly, I have changed my mind. It is not unchristian to curtail suffering. Well, as if that wasn't enough, a moral giant of our time, Archbishop Desmond Tutu, came out in favor, and he was quoted as saying, I have spent my life fighting for the dignity of the living, and now I want to fight for the dignity of the dying. Well, also during this time, one state after another began to pass the Oregon model, while 20 other states had bills pending. So there started to be more interest among League chapters throughout the United States. And so I was on a panel in San Diego because League wanted to take it up as their main issue. And after that, they asked me to come to their national convention and present the same thing. But before I got to do that, as you may know, California passed the Oregon model. I'd like to make a prediction, which is there are 70 million baby boomers in the pipeline, okay? They're starting to come off into retirement in very substantial numbers. This is a selfish, self-centered generation. Obsessed with career. They haven't really thought about this issue until they retire, and then it's slowly becoming front and center for obvious reasons. This is also an activist generation. Think back over time from the 60s. This generation has taken on and won every issue it tried: anti-war, civil rights, women's rights, gay marriage, you name it. This generation knows how to organize, lobby, get out a newsletter, educate the public, and harass their public officials. And one thing they don't know how to do is accept no. Okay, it's been said that we've been coddled, you know, this generation raised in the 50s. We don't understand no. What do you mean I can't? We're going to change it. So I predict in the next 10 years, there's going to be a sea change, which has already started on this issue. And in conclusion, I'd like to quote Victor Hugo. There is one thing stronger than all the armies of the world, and that's an idea whose time has come. Thank you.
Thank you, Margot. Appreciate your time today and your comments about some background on what was happening in Arizona. Next, we have Representative Debbie Armstrong. Representative Armstrong was first elected in 2012 to the New Mexico House of Representatives, representing District 17 in Albuquerque. She chairs the House Health and Human Services Committee and was the sponsor of New Mexico's Elizabeth Whitefield End-of-Life Options Act, which was signed by Governor Grisham April 8th, 2021. She also serves as a senior advisor to End-of-Life Options New Mexico, a newly created nonprofit focused on implementation of the act. Ms. Armstrong is also the executive director of the New Mexico Medical Insurance Pool and former cabinet secretary of the New Mexico Aging and Long-Term Services Department. She has more than 45 years of healthcare related experience, including home health, hospice, and long-term care. She is a former physical therapist and attorney with a bachelor's degree from the University of Michigan in 1975 and a law degree from the University of New Mexico in 2001. On a personal note, Ms. Armstrong has an adult daughter with advanced stage 4 cancer who has been a strong advocate in her own right for medical aid in dying. Welcome, Representative Armstrong.
Thank you. Thanks for having me. I appreciate the opportunity, and I've been asked to share with you New Mexico's path to passing of our End-of-Life Options Act, who is named for a beloved judge in Albuquerque who was a strong advocate during the last year of her life, and for the first time that I introduced the bill in 2017. First, I'd like to set a little bit of context, and that is New Mexico has a very long history of valuing autonomy in healthcare decision-making. We were the first state to enact the Uniform Healthcare Decisions Act in 1995, so around the time that Oregon was working on passing their end of life, their death with dignity. And that act establishes the right to make healthcare decisions, including refusal of care. Of course, it addresses surrogate decision makers, which doesn't, it is not pertinent to end of life, but importantly, and we reference it in our law, is that it assumes capacity to make decisions unless there's a reason to question that. Just a little bit of a timeline of our path. We actually there was introduction of a bill in 1995 by a one-time one-term senator. She later came back and co-sponsored with me as we got this passed. It, as Arizona's have died in the first committee. In 2009, a one-term representative also introduced a bill, and it died in its first committee. So advocates in the state thought, well, we've tried twice in the legislature, and there was not, perhaps there wasn't a strong champion that had to continue introducing it. So they tried legal action. We had in 2012, Morris v. New Mexico, but the district court ruled that it was a constitutional right to medical aid in dying. However, appeals court reversed, and the New Mexico Supreme Court upheld the appeals court decision. Their decision was issued in 2016, saying it's not a constitutional right, it's the role of the legislature to decide. So back to the legislature. I was elected in 2015, so after that decision, introduced a bill in 2017, End of Life Options Act. We introduced it in both the House and the Senate. The House made it through one committee, died in the second. The Senate version made it all the way to the floor and lost by just 2 votes. We reintroduced it in 2019. It made it to the House floor, but wasn't brought up for a vote. We didn't try in the Senate since we knew we had to get through the House. The Senate was close. And then we reintroduced it this year in 2021, and it passed the House 46-20 and the Senate 24-17. So how did we do that? When we knew we had to go back to the legislature, a broad coalition formed of interested individuals and organizations to begin our legislative advocacy efforts and strategizing for building support, public support and legislative support. We partnered with Compassion and Choices, who provided us a state-based organizer and other support, and Death with Dignity was also very engaged and supportive. Both helped us in reviewing our draft legislation and provided us quite a bit of support, which was an important factor. But what else did we do? So our coalition steering committee met monthly for years since the beginning, so in between legislative sessions as well. We had public polling to make sure we were consistent with what Val said the polling looks like. We had strong public support. We created a website, newsletters, a listserv to keep people engaged. We created geographic action teams that did local outreach and education. We made presentations to every professional and community organization that would have us, providing tabling at conferences if we weren't providing presentations. We gathered endorsements. We were able to garner engaged neutrality position of the Medical Society and the New Mexico Disability Rights organizations. So they were not in opposition and engaged with us and on language in the bill and in providing testimony as well. We were able to get city council resolutions unanimous in Albuquerque, and Las Cruces was almost unanimous, definitely bipartisan in Santa Fe. We began a little bit of fundraising and also some small grants to help support us. Volunteers across the state met with and wrote their local legislators. We surveyed legislative candidates to identify supporters, and then many individuals on our campaign became active in some of those campaigns of legislators who were supportive of aid in dying. We met with local newspaper editorial boards. We got endorsements by the major newspapers. We were able to get very balanced articles out of reporters. We wrote letters to the editor and op-eds. We had a paid lobbyist during the session who coordinated with other advocacy groups and closely, of course, counted votes, provided legislative testimony, and of course, emailed updates to the listserv. But one of the really big things that we did was, and our focus was storytelling. We did storytelling in testimony. We coordinated individuals to make sure that we had a wide variety of storytelling and situations. And we published a book of stories. This one is about Elizabeth Whitefield, who is the bill is named for. You can find it on our website. This link is actually Compassionate Choices has it on their website, but we have it on ours, End of Life Options NM.org, and I'll have that reference in a moment. It contains about 20 stories. We provided these to all the legislators, so they were delivered to the legislators. We also, on Compassionate Choices, helped us produce videos. We had a number of video testimony. And of course, other factors, politics. We had between the 2019 and 2021 session, there was an election, and we increased the membership that were in support. So a number of legislators who had not been supportive lost their seat and were replaced by members who were in support. That, of course, wasn't the only issue, but it was, we worked hard on that and was definitely a factor. And we had a change in governor to a governor who was affirmatively supportive of the bill and of medical aid in dying. And so with help from the governor as well, we were able to get it passed. And I also think it was important that as a sponsor, I was the primary sponsor, but I was chair of the House Health and Human Services Committee, which guaranteed it was going to get a hearing. And I have a professional and personal interest in death and dying. I, along with a law professor, Rob Schwartz, were the primary authors of the legislation. So I knew the legislation inside out, upside down, and could negotiate each and every word or comma as necessary to move it forward. And we increased the number of co-sponsors over the years. And during that time, we also began planning for implementation. At least a year before we passed the bill, we started recruiting supportive clinicians, pharmacies, hospices, and began thinking about what it would take. After the passage, our coalition that had worked on this became a nonprofit, End of Life Options New Mexico. We incorporated, have filed for nonprofit status. I serve as a senior advisor to End of Life Options, and we intend and are serving as a information clearinghouse and referral source for providers and patients, and a source of education and support to individuals, healthcare providers, organizations, and communities regarding the full range of end-of-life options, but and having specific knowledge and medical aid in dying. And that we're able to get that going and working with a lot of pro bono and monetary donations. We've had actually more than, we've had 14 that we know of, ingestions that have taken place since the effective date of the law, which was in June. So we have a lot of hospices actively engaged, the university, the biggest healthcare system in the state is supportive, and numerous other individually practicing providers. I'd like to, I won't spend much time on this, but I do want to mention that a couple of things, and they're in the slides for you to look at later, but New Mexico's law is not like Oregon's. And we started with that, of course, but we looked at the history of the usage in other states, and knowing New Mexico, we made a number of changes that make our law unique, that we believe takes away unnecessary barriers and makes it a little bit easier to access. I'm not going to talk about the whole law, but just the differences. The first being that a prescriber can be a nurse practitioner or physician assistant. We have had independent practice nurse practitioners for decades, and our physician assistants are a breath away from being independent. And in many communities in New Mexico, they're the only providers, and maybe the provider that an individual knows and trusts the most. There must be a consultant physician that must affirm the terminal diagnosis, however. So a physician does have to be involved in determining that the individual is qualified. However, and this is another unique feature, enrollment in hospice is an auto affirmation of terminal diagnosis. Because of the way the laws work for hospice, a physician has affirmed that terminal diagnosis and that of 6 months or less prognosis. So if by chance it's a nurse practitioner who does the prescribing, there only needs to be a physician consultant to affirm the other, and the individual is in hospice. The consulting physician only needs to affirm the other eligibility criteria. Capacity is assumed unless the provider has reason to question that, or if there's a recent, current or recent disability or mental illness that could impact end-of-life decisional capacity. And then they have to be referred to a mental health professional to determine whether they actually have capacity to make an end-of-life decision. And that mental health professional is not limited to a psychiatrist or psychologist, as some states might be. There's a wide variety of mental health professionals who could be the determiners of capacity. Self-administration in our law is defined as taking an affirmative, conscious, voluntary action to ingest the MAID medications. Unlike, as Val said, our law is silent on whether that has to be done independently and without assistance. So we're assuming that assistance is allowed. The only waiting period, and many other states have a waiting period between asking first and second time for as long as 15 days. The only waiting period in our law is 48 hours between writing and filling of the prescription. And even that can be waived by the prescriber if they believe the individual might not survive 48 hours. We believe that the other waiting periods in other states are artificial and unnecessary, and often individuals die while waiting to get through those bureaucratic timelines. The whole process takes some time, but if you do everything and all the steps and are affirmed, we don't believe you should have to wait. We have a separately standing provision of right to know, where all providers must inform their terminally ill patients of all reasonable and legally available options. And that doesn't mean waiting to be asked. That is an affirmative responsibility. And providers who do not want to prescribe when asked must refer to another provider, or they can refer to an individual or entity who will assist. And for us, the End of Life Options New Mexico is an entity that would meet that qualification. So you can refer to us and we will help find a provider. And then just the link to End of Life Options New Mexico, of course, Compassion and Choices, Death with Dignity. American Clinicians Academy on Medical Aid in Dying is a fabulous organization that is providing clinical education and support. It's based in California. I have my email address and a link to the final bill. And with that, I will turn it back over to you, Mary.
Thank you, Representative Armstrong. It looks like they found that strong champion in New Mexico after all. For our next speaker, Monsignor McCarthy from the Catholic Diocese of Tucson was to be our fourth panelist and he needed to cancel. We are very grateful to Amina Donna Kruk, who agreed to fill in for the Monsignor at the last minute. Amina is a disability advocate who has lived with disability most of her life. She is a member of the National Council on Independent Living and co-chair of their Employment and Social Security Subcommittee. Amina recently retired from a 40-year career as an Arizona licensed counselor and was vice president of advocacy programs at Ability 360 in Phoenix. While at Ability 360, Amina developed programs to empower individuals with disabilities and their families, including Get Out the Vote activities, a peer mentoring program, wellness groups, Social Security disability work incentive counseling, and consumer-driven initiatives. She developed community partnerships to address barriers to consumer choice, equal rights, and self-determination. She was a lobbyist for Ability 360 and taught workshops on the legislative process, disability awareness, ableism, and advocacy. She received her Master's of Counseling at Arizona State University and resides in Phoenix. Welcome, Amina, and thanks again for filling in on such short notice.
Thank you. Thank you. It's a little intimidating. This is a very well-studied group who've thought long and hard about this topic and worked very hard to pass these laws. I feel honored to be here with you all. And Margo, I was probably at that hearing you were at, the one hearing we got where people got to speak on this topic in Arizona years back. Well, I'm a little nervous. I had to kind of like cram for the test ahead of time in a way, and that I haven't really spoken on this issue for a long time, but it is a topic that is near and dear to my heart because I've actually explored this topic in depth with a friend of mine who has quadriplegia and many other disabilities. And we've read books on Aiden dying together and talked about this topic. Today, I'm here to assure you that you will hear from people with disabilities who oppose legalization of what our community calls assisted suicide. I understand that's an offensive or a non-appropriate term. I understand that those fighting for aid in dying want to relieve people who are dying from unnecessary suffering, and I respect that desire very much. I just recently went through several melanoma surgeries, and I'm still in that waiting period to see if I'm clear. And so I know a little bit about what that's like. Unfortunately, we live in a world with economic inequity, insurance denials for treatment and medications, systemic racism, and ableism. I'd like to share with you some thoughts on the topic that may be new to you. Fortunately, there are other ways to relieve suffering during the dying process. And I just, as I'm listening to everybody talk, I have to say that, you know, this is a cultural issue. We have a culture that is basically in denial about death. Mostly death does not happen in the home like it does in other cultures where it's part of living. We have a great fear of pain and being out of control as a predominantly white culture. And many people feel like they'd rather be dead than disabled, like my friend Valerie. But Valerie doesn't feel that way. She's only feared about what's going to happen if she has to go into a nursing home and won't really be cared for the same way she is at home with her home and community-based services, which Arizona is a leader in providing. So many national disability groups are opposed to the legalization of aid in dying. American Association of People with Disabilities, Association of Programs for Rural Independent Living, Disability Rights Education and Defense Fund, National Council on Disability, Not Dead Yet, the Archiver of the United States, and the United Spinal Association USA. Those are a few of the organizations. So there's been a vigorous debate within the disability community that was a constituency of a lot of different coalitions. They span the political spectrum from left to right, as do those who are supporting aid in dying. They include disability advocates, physicians, faith-based organizations, and other groups, including assuring that other ethnicities and races are included. These strange bedfellows in this coalition often agree on nothing except that assisted suicide should not be legalized. And I'm going to talk about some of those reasons. Far more state proposals are rejected than passed, often due to the work of these coalitions to educate about the dangers and harms of aid in dying laws. I want to tell you first about Not Dead Yet. Margot mentioned them. They are a leader in the disability community about this. They, the initial organizers are people who grew up with very significant disabilities from childhood. So they don't identify with the tragedy of acquiring a disability. That is who they are, okay? And so they have a different perspective than some people who acquire a disability later in life. They're a national grassroots disability group that oppose legalization of assisted suicide and euthanasia as deadly forms of discrimination against old, ill, and disabled people. Not Dead Yet helps organize and articulate opposition to these practices based on secular social justice arguments. They demand equal protection of the law for the targets of so-called aid in dying, whose lives are perceived as worthless. So I'll talk about ableism first. It's a set of practices and beliefs that assign inferior value or worth to people who have developmental, emotional, physical, psychiatric, visible or invisible differences, conditions, functional abilities, or disabilities. Some people call them that. Ableism is a systematic, intentional or unintentional prejudice and oppression that assumes that there is a normal and a not normal. In reality, ability and functionality are on a spectrum. The public image of severe disability is often that it's a fate worse than death. So there's a double standard. Legalized assisted suicide or aid in dying means that some people who say that they want to die will receive suicide intervention while others will receive suicide assistance. So who gets what? And I think over the years, it's sounding from what Deb has said that there's been more effort to include the disability community in the development of these laws and to be careful about the dangers it provides to people with disabilities. So if you could put the photograph of Diane Coleman up, I'd appreciate it. So I'm going to tell you in Diane's own words, I'll speak for her. I have an advanced neuromuscular disability. 6 years ago, I went into respiratory failure. I now use a ventilator with a CPAP mask about 22 hours a day, without which I would die in a short time. As a disabled person who depends on life-sustaining treatment, I could qualify for assisted suicide if I lived where it's legal. If I became despondent, if I lost my husband or a job and decided that I wanted to die, I would not be treated like a healthy non-disabled person who despaired over divorce or job loss. Throughout my adult life, I have worked full-time, first as an attorney and then directing small nonprofit disability organizations. I've also run a group I founded in 1996, Not Dead Yet, which now has 3 staff, a few contractors, and volunteer advocates across the entire country. I have spoken at conferences, lectured at universities, published articles, submitted legislative testimony, and provided day-to-day management in organizations that required it. I'm not saying this to be inspirational, but to make it clear that people like me have good lives and should not be written off. Okay, thank you. You can take the picture down. So there's some questions about quality of life judgments that are made by the medical professionals, which often it's their judgment that's being used. So physicians, therapists, counselors, all have biases, and they have biases about dying, just like everybody else does. So there was a survey done of 714 practicing U.S. physicians nationwide, and 82.4% reported that people with significant disabilities have a worse quality of life than non-disabled people. Potentially biased views among physicians could contribute to persistent healthcare disparities affecting people with disabilities. So I can tell you stories of people's lives. I'm going to go ahead and talk now about the pandemic, which is really up front in the news. The doctors decide who's eligible for treatment with COVID. Over the past year, COVID-19 pandemic has brought to light that people with disabilities have been denied treatment out of prejudice about the quality of their life due to this pervasive bias that's within the medical community. An example in Texas that's deadly and is an example of racial disparities combined with ableism is Michael Hickson, who was a 46-year-old Black man from Texas. Mr. Hickman was quadriplegic. That means he did not have functioning arms or legs for the most part. And this was the result of a brain injury caused by a heart attack. He was placed in a nursing home where he contracted COVID-19. But due to his disability, the doctors decided to withhold all treatment, stating that he had no quality of life. He was placed in hospice and died. His family did not have that same perception about his quality of life. Most reasons people give for seeking assisted aid in dying is that they have a terminal condition representing a steady loss of autonomy, decreasing ability to participate in activities that made life enjoyable, loss of dignity, physical or emotional burden on family, friends, or caregiver, loss of control of bodily functions such as incontinence and vomiting. So this comes from Oregon data. So this is really an economic issue, and it reminds me a lot of that exercise we had in school that I always hated, which was you're in a boat and there's not enough room for everybody, so who do you throw out of the boat? So people with disabilities are used to being the ones being thrown out of the boat, as are people of color. We have to consider the real world we live in. There's a deadly mix, a combination of aid in dying and our broken profit-driven U.S. healthcare system and legalizing aid in dying, which would be the cheapest so-called treatment. Insurance place restrictions on medical supports and supplies, often that will still fund assisted suicide. Direct coercion is not even necessary. If insurance deny or even delay expensive life-saving treatment, the person will be steered toward assisted suicide. Will insurance do the right thing or the cheap thing? And it's not just about treatment for the condition, but it's supporting. We have a problem in this country about not wanting to provide the supports that makes it possible for people to live with a quality of life with a disability. We have a shortage of funding for our long-term care, as I'm sure Deb knows, as she's worked in that field. There's not enough funding to get caregivers. In this economy right now, it's desperate. They're actually moving people in Arizona from home community-based services back into nursing homes, which are life-threatening right now during a pandemic because we can't get caregivers for the pay that is offered. So I have examples of this also, which are difficult to say. One is in Oregon, where the woman herself was a grandmother and had recurring lung cancer, and a man who had prostate cancer. Their prescriptions prescribed chemotherapy, and the insurance company denied, but sent a letter saying the plan would not cover that, but it would cover among other things, physician-assisted suicide or aid in dying. Stephanie Packer is a young mother that was in California with the children, 4 children. She had scleroderma, an autoimmune disease that hardened her lungs, and she testified that shortly after California passed the law permitting assisted suicide, her insurance company denied her coverage for chemotherapy. However, they said they would pay for assisted suicide and that her copay would be $1.20. So yes, it's an extreme example, but that's why I'm here. I'm here to talk about the extreme examples, okay? We have a lack of palliative care in this country, which would offer comfort care to people who are terminally ill. And ideally, comfort care would include social and lifestyle as well as medical interventions. We're in an opioid crisis, and therefore right now, physicians are afraid to prescribe enough pain-killing medication for some people, which is a lot of people are afraid of the pain. Although you saw that that wasn't actually one of the top 5 reasons that people were seeking this. There's financial pressures and emotional pressures that can make people choose aid in dying. Our culture is not conducive to dying. It may take time. A lack of family paid leave, a lack of respite care for assistance are a burden, not on the dying person always, but on the persons who are helping care for them. There's a desperate lack of funding for home and community-based services, home modifications, assisted devices to help the patient and family and improve quality of life. Also, the pandemic has brought about more awareness of racial disparities. People of color or people from marginalized communities are at greater risk from assisted suicide laws because racial disparities in healthcare make it more likely that doctors will write off patients as terminal, make it less likely that patients can afford life-saving treatment, make it less likely that patients will receive adequate pain treatment. My friend Valerie is trying to get palliative care. All she would have to do is stop using her feeding tube. Then she would be called terminal, and then she would qualify. So this leads to limited choices and poor health outcomes. A 2013 Pew Research study, Minority Opinions on Assisted Suicide, shows that Blacks and Latinos are 65% opposed to medical aid in dying. There's questionable protections. I think this is something that Deb was talking about. They tried to look at what wasn't working well with the Oregon bill, and I'm grateful that they did that. It requires any medical professional to be present when does not require medical professionals to be there when the medication is ingested to ensure that the patient's voluntary decision or to deal with possible complications. It requires that any witness attest to the patient's, it doesn't require that any witness attest to the patient's physical or mental capacity when the drugs are actually ingested, or to confirm that the patient's decision was voluntary at the time. So it's a double-edged sword, this autonomy piece of it, in that it does leave open some opportunity for undue pressure from family members, which I've seen that again. There are family members that fight for the best wishes for their people in their life with disabilities, and others who unfortunately take advantage of them, and that's just a reality. Also, the diagnosis of terminal illness are wrong on occasion. Sometimes the predictions are unreliable. 12 to 15% of people graduate from hospice. They leave hospice, they don't die. How could the doctor know if the person is being pressured or abused at home? They don't even have to personally really know the patient in many cases with these laws. Although self-administration is a key safeguard because the person is taking it themselves, but there is no independent witness to say that that's what's happening at the time. So we don't really know if that's the case. Doctors are not liable if they act in good faith like they are in other forms of medical procedures in most of the laws. So, and in fact, the Oregon law says that no person shall be subject to civil or criminal liability or professional disciplinary action for participating in good faith compliance with the Death with Dignity Act. Lack of oversight rather than transparency. Is the data available? Are questions able to be asked? Are they keeping the data so that we can see what is actually happening? Is there any investigation? Oregon destroys their data annually, for instance. So the failures of safeguards, thank you, with people who with depression are significant, and I have examples of that, but I won't go into it. But it's very tricky, and often if people's concerns are addressed, then they are not as anxious to have Aiden dying. There is a problem of suicide contagion. Since the bill in Oregon was passed, Oregon's suicide rate in 2007 was 35% above the national average, and in 2010 it was 41% above the average. And there is a slippery slope issue because these bills have often gone back to expand the law and make it easier for people to seek this with less control. So I have 30 seconds. So in summary, there is a vigorous policy debate within the disability community and other civil rights activists regarding the issue of choice. While some individuals may be saved from mistakes, coercion, and abuse, a public policy of assisting Aiden dying ignores the significant impact on society of the larger group of people who don't have access to high quality health care, financial resources, a loving available family, and who are subjected to discrimination based on race or abilities. With assisted Aiden dying laws, as the points above illustrate, choice for the few means harm for the many. Importantly, there is an alternative. Anyone dying in discomfort is not otherwise relievable, may legally receive palliative sedation, wherein the patient is sedated to the point that the discomfort is relieved when dying process is taking place. So there is already a legal solution. And I literally have one of my longtime teachers and friends in this process of dying right now, as we all have vigil with her while she's in that process of passing. So thank you very much for this opportunity to share this information.
Thank you, Amina, and thanks again for coming in at the last minute. And we really appreciate your time today. We're going to open this up now for the Q&A. I'm going to start by, since you just finished, I'm going to start with a bit of a longish comment and then a question by someone in the Q&A. She says, as an individual who lives with a disability and has a bit of a different perspective, I worry we're placing too much cultural burden on the dying individual to fix these issues. I worry we're asking dying individuals and disabled individuals to give up their wants of a hastened dying process because of the broader cultural worries. The decision should come from the individual and not be concerned with our broader viewpoints. It may be true that someone is assigning their own life less value, but they aren't oppressing themselves by relieving suffering. And here's kind of a question here that she has about an argument that medical aid in dying is, there's an argument that medical aid in dying is too restrictive and may be unfairly restricting the rights of disabled individuals who want this opinion. we need to fix the biases, but if we take out the subjective quality of life measurements and go to objective ones, shouldn't someone be able to decide for themselves? Autonomy is very important to many of us. Much respect to all the panelists. So what about this idea that she has in the middle there, that some people think maybe the laws as written are too restrictive? And I also want to mention, I believe that palliative sedation, which you mentioned at the end, is legal in all 50 states. Yeah.
Yeah, actually, my friend Valerie that I talked about, that's really one of her concerns, because she's been a quad now for over 40 years. And one of the big problems for her, besides many body functions not working well, is the fact that she's got severe osteoporosis, which means now just getting transferred, sometimes a bone can get broken. And that's really terrifying to her. The lack of control and what would happen if the time came when she couldn't take medication on her own. So we've had that discussion as well. And I think that Val mentioned that too. Some people are concerned about that fact that the person has to do it themselves. I think one of the reasons that that's in the law is because, quite frankly, in other countries, for instance, the Netherlands, who's been probably having these laws the longest, have gotten quite liberal, including that someone with depression can ask for aid in dying. And so there is just a real concern that it wouldn't be the person's choice. And so none of these, there's no easy answer to any of this. I just want to make sure that people understand how complicated it really is, because if you haven't lived with a severe disability and been discounted many times when you go to the doctor, in fact, then you don't know where they're coming from.
Thank you. You're right. It is a complicated issue. Representative Armstrong, you have your hand up.
Thank you. I just want to really thank Amina for your perspective. I don't disagree with anything you said about the social injustices and the issues around disability. And for instance, I've worked on trying to promote disability rights and disability services and home and community-based services and adequate care for a long time. I don't disagree, but I do have to say I get more comments like the one that was just read, and more complaints now about the law doesn't go far enough for persons with disabilities. So it is a complicated issue, and I really appreciate your perspective. I don't think we should stop working at all on those broader issues. But as you know, and are experiencing with friends, even persons with disabilities become terminally ill with cancer or other things that, and autonomy to the end is my view. Very small number of people actually select and want to use medical aid in dying, and so I'm hoping we can protect that for those who choose it. But thank you very much for your comments. I appreciate them.
And thank you, Representative Armstrong. I have a couple of questions for you also specifically. And while you're on, I'll just ask you quickly. Somebody asked, can an out-of-state resident move to New Mexico for the purpose of taking advantage of your end-of-life option?
So yes, if you move there. So if you have moved away from and don't have another residence and move to New Mexico, we don't have a time limit on what that is or what that living arrangement is. It's not a vacation destination to do this, but if you have moved, you can move to New Mexico and you don't have to live there for some certain period of time in order to utilize the New Mexico law.
And the other question is, what was your experience with the Disability Rights New Mexico lobbyist in New Mexico?
We had a very good working relationship as I said, I've worked with them for a long time on a lot of issues. We had lots of discussions. We specifically added in on the capacity portion of any recent disability or mental illness that could impact decision making, that has to get referred to a mental health professional. That was language. That specific language was negotiated with the disability community. We had a number of people with disabilities who testified in favor. We had some national disability groups that came to talk against it, but local organizations representing disabilities, some spoke up as being neutral and engaged.
Thank you. Val, someone asked if we could possibly put the list of states that have passed a law back up on the screen. And someone wants to know, someone has a question about life insurance. Does life insurance pay if one chooses an end of life option?
Sure, if you're okay, I'll answer that and then I'll put my screen up. Because the laws have very pragmatic language around how a death under the law is defined as not a suicide, not euthanasia, not a murder or manslaughter and so forth, there's no reason a life insurance policy shouldn't be paid if it was properly kept up and maintained and kept current during the life of that patient. And so now I will share my screen and put that up. And this is also available on our website, deathwithdignity.org. We have a list of all the states. So I hope everybody can see that, and I'll just leave it there for a little bit.
The other question about insurance is, should we look to create more regulations to ensure insurance companies are not denying coverage for proven treatments in favor of aid in dying?
I'm happy to just weigh in on the fact that I think we definitely have a lot of room for improvement across our country through our healthcare systems. And I think it's necessary for us to continue working on the issue of ability to access healthcare, the economic challenges that people have when they can't afford insurance and so forth. But I think that it is a separate movement to the medical aid in dying movement, which really seeks to promote patient-directed care at the end of their lives according to their own values and wishes.
So the same attendee mentioned it should lend itself to opening, pushing for greater palliative care options. And I agree with Amina that, COVID-19 has amplified so many issues that have been around for a long time that we weren't talking about, the inequities in healthcare, what's happening in nursing homes. And it has now forced people to have the discussion of death and dying around their kitchen table, maybe for the first time. They're thinking, gee, maybe I do need to look at doing advanced directives. Maybe I do need to talk to my kids about my wishes. So it's really created a lot of good conversations with families and loved ones. So it's a little bit of
I'd like to make a comment. I didn't put on my resume, but after I retired, now I'm very interested in aging issues. I'm 73, and I took actually a course in death midwifery, so I'm looking at this issue from all perspectives and about how to be helpful. And right now we're seeing, actually at this very moment, they're talking about hospitals in certain states are actually in full capacity, and they're starting to invoke their decision-making tree about who's going to get treatment. And well, unfortunately, we're probably going to get another opportunity to see examples of whose lives are valued or devalued. Yeah, I just wanted to mention that.
Thank you, Amina. Val, you have your hand up?
Yeah, I would just like to add a little bit to that conversation. You know, on the one hand, triage is a difficult process. We've seen the disparities and the justice issues around what has happened during COVID. But on the other side of that conversation, I would encourage people to have the personal conversation within their families, particularly, you know, what happens if you get COVID? What happens if they start talking to you about being on a ventilator? What happens? What do you want your family to do if they have to triage? Probably the most difficult discussion I've ever had with my son was last year around March, April, when things were getting into full COVID swing, of having a conversation with him that I would be okay that someone younger and stronger than me could have the ventilator if there was only one between the two of us. Because I've lived much more of my life in the past than I will have the opportunity in the future. And I also filled out a new advance directive with him and discussed with him and my daughter-in-law that I didn't want to be on a ventilator, you know, and all of the other wishes that I had. So it was very clear to my family members how they could make decisions for me based on my own values. So please don't ever underestimate the power of those conversations within your family and among those you trust to be your healthcare agent.
Thank you, Val, for saying that. You know, as I've been speaking to more seniors or elders about this topic, I mean, some of them literally leave the room. They can't, it's very difficult for them to even start to think about it. And I think of one of my friends that was in that situation. She literally walked out of the room. They'd asked me to come and talk to this group. And unfortunately, within a couple months of that, her husband got cancer. He had just retired and died very suddenly. And all of a sudden, she was, you know, calling me and saying, you know, now we have to fill out these forms. We have to figure this stuff out right away. So, yes, it would behoove everybody to start having this conversation, because it's the one thing we know is going to happen to us all. We don't know how, but we know it's going to happen.
That's right. And it is
100%.
challenging. You know, we talk about how difficult it is to talk about death, and yet as you begin to talk about it, it's not so difficult anymore. And I always like to remind people too that talking about dying is not what's going to kill you. So it's an easy conversation after that.
Margot, you can unmute and ask your and comment.
A lot of the issues that were raised in connection with disability are discussed in the white paper, the League's white paper, and there isn't an opportunity today to go through point by point, but I encourage everybody to go online and read it, because I think it can be helpful.
Similarly, we do have links, and there are links related to the disability concerns. And many of the examples that I have, many I didn't have time to share, came from a danger of assisted suicide laws that was published by the National Council on Disability in 2019. And you can, you know, Google and find that easily too.
We'll have resources on our website that I'll talk about it in a minute. Another question came up about specifically about the law, and you know, it's interesting the way Montana always, when you list the states, there's always a little asterisk next to Montana because it's such an unusual state. It didn't have a ballot initiative. It didn't pass by the legislature. So the question is, which law in Arizona, and I hope you can answer this, Val, which law in Arizona specifically prohibits medical aid in dying? Would it be easier to repeal that law and follow the Montana example? Or do we need to create a whole new law to allow medical aid in dying in Arizona?
That's actually a great question. There isn't a law that prohibits aid in dying. The challenge is that without a law that sets up parameters around aid in dying, an individual might be accused of assisting someone else's death or being involved in someone else's death. So it's the laws of the state that say, you know, you can't assist someone who wants to die. You can't be involved in a death of any kind. A physician can't write a prescription that is a lethal dose to a patient without a law that says he or she can. And so that's the challenge. It's not necessarily repealing laws that are in place, but it's creating a law that says this kind of death under these circumstances, under this medical standard of care, is not all those other things you might otherwise want to take legal action against.
And go ahead, Representative Armstrong.
I was going to say the same New Mexico had the law on the books, which our Supreme Court wouldn't overturn it, against assisted suicide, euthanasia, etc. It is still on the books. We modified it to say that if you follow the End of Life Options Act in good faith, it's not one of those things. But if you don't, the reverse of that is also true. If you don't follow in good faith our new law, then you could be guilty of a felony. And so it remains on the books modified. But that, I would assume, is a law on the books probably in Arizona as well, of not being able to do assisted suicide or euthanasia.
It is a law on the books here. Yes. Val?
Yes, I would just add a little bit more about Montana. Every year, the Montana legislature introduces a bill that would try to criminalize Aiden dying. Fortunately, every year that fails. I think that's how opposition really wants to turn over that ability of the people in the state of Montana to simply have the conversation with their physician when they're terminally ill, without the need for any legal involvement. But it's challenging to the state of Montana every year because they don't have a law that clearly defines things.
Here's another question. I think they're referring to the New Mexico law because you so specifically laid out the provisions, Representative Armstrong, and I think this might be addressing the topic of abandonment. It says, why is there a provision in the law that requires an autonomous physician to be complicit by referring if they disagree?
Yeah, there is a requirement that if you don't want to participate, you do not have to, no provider has to participate. No institution, healthcare institution has to participate. They do, however, have had that they have to make that known publicly, and the individual provider must refer to another provider if they know, or to an entity that will help. They just need to provide them some information so that they can seek the help they want. But there is no requirement that anyone participate or that they actively go and find them someone that will. They just need to refer them to someone who can help them. And they have that affirmative responsibility to talk with their terminally ill patients about all options, all legally and reasonable medical standard of care options available.
And other healthcare professionals can opt out also, meaning the nurse, the hospice worker.
There is no one that has to participate.
Mm-hmm.
And they can't be, and we're really clear that you can't have any disciplinary action or any negative consequences to you in your employment or your licensure for choosing to participate or choosing not to participate. And a healthcare entity can deny their employees from being able to participate and can deny the ability to do it on their premises. They can't, however, keep a provider from doing it outside their scope of employment and off premises, off hours. But they can, for their employees in their scope of work, deny their ability to participate.
I noticed California in their amendment that recently went to the governor's desk, that they also require healthcare facilities to post on their website whether they are for or against medical aid in dying. There's just a couple of other comments. We're running out of time. I think the answer to this is very simple. If a person has a health power of attorney, can that person ask the medical provider for the lethal prescription? I think.
No. That's a simple answer. No.
Yeah.
Has to be an individual choice.
And during the hearings, you had a great statement where you talked about advanced directives are to instruct people when you're incapacitated and cannot make decisions for yourself, where medical aid in dying is almost the opposite, where it has to be your decision and you have to be able to voice that request.
That's correct.
Yourself. So even though advanced directives are very important, they can't really play a part in medical aid in dying. There's also, we have the two national groups, Death with Dignity and Compassion and Choices. Here in Arizona, there's another group called Choice and Dignity, and we will post their website under our resources. And there's another group also, Arizona End of Life Options. Thank you we've run out of time. I'm sorry I couldn't get to everybody's question. Thank you for a lively discussion, and thanks to all who sent in questions and comments. We will post a list of articles, websites, and other resources on the Greater Tucson website if you want more information. If you enjoyed the program and want to share it with friends or loved ones, it will be available on the League website, which is lwvtucson.org. I want to acknowledge the League committee that organized the program, including Judy Moll, Floyd Parkhill, Mary Ann Mills, Susan Black, and the chair of the voter education program, Elizabeth Zagura, for her guidance. Thanks to Judy Wood as coordinator, and Jeremy Biddle and Adrian Barton as our tech hosts today. And kudos to our brand new intern, 𝗩𝗹 𝗟عني from the University of Arizona, for her help with publicity. And lastly, a big thanks to our panelists, Val Lovelace, Margot Champagne, Representative Armstrong, and Amina Donna Kruk, for your time, expertise, and thoughtful presentations. Tune in to the next voter education program, the third Saturday of the month, which is always free and open to the public. And please consider becoming a member of the League of Women Voters. Thank you for attending.